Thank you, Madam Chair, and we thank the panel for the opportunity for Santos to appear before you again in relation to the inquiry. My name's Bill Ovenden. I'm accountable for exploration and appraisal activities at Santos. And to my right, just for the sake of efficiency, perhaps if I could introduce everyone else, Paul Wybrew, who's an environmental officer, a senior environmental officer with us, Cockatoo-Collins, who's a senior Aboriginal engagement officer, Tom Baddeley, public relations with Santos, Geoff Atherton, our general manager of drilling operations.
Thank you.
I too would like to acknowledge the Larrakia people on whose traditional lands we meet, and I pay my respects to their elders, past, present and future. I guess initially I'd like to confirm Santos's belief in the gas resource potential of the onshore Northern Territory space, and particularly the resource potential of the MacArthur Basin. It's early days, but we believe it's a tremendously valuable potential resource for the Territory in the future. And we'd like to confirm Santos's belief in the importance of gas in the Australian and the global energy mix as an affordable component to a sustainable low-carbon future. I guess, again, initially I'd like to congratulate the Chair and Madam Chair and the panel for the excellent report that's emerged in the interim times of this inquiry. The terms of reference were very, very wide. In fact, it's more an inquiry into the impact of the industry than it is into fracking. But I think the report that you've produced here is testimony to an enormous amount of effort in engagement with stakeholders right across the spectrum. And we'd like to just thank you for that state of play that you've provided. It's a really impressive document. Our purpose is to address some of the issues raised in that report as a precursor to a written submission, a more formal written submission.
Thank you.
The recurring theme, I think, in the report, for me anyway, is the requirement for a more robust regulatory framework in relation to the. Is there something? That, no. Yes. Can we fix that? Do you want microphone? Do you want that? Do you want to wait a bit, Madam Chair?
Wait for a moment.
Yeah, no worries.
Reassemble what I've brought.
Yeah, no worries. We're good.
Thank you. Sorry about that.
No, no problems.
Too much coffee.
Yeah, I can sympathise. The recurring theme in the report, though, is the requirement for a robust regulatory framework. That's the impression I take away. And we strongly support this position, actually. We acknowledge the shortcomings of the current regulatory framework in view of the potential for a large unconventional development in the onshore space. I guess, personally, when I read the document, my concerns arrive with some of the stated intent, perhaps around the operationalisation of the precautionary principle, that is, the treatment of uncertainty with perhaps prescriptive exclusion or over-prescription. That it sends a little shiver of fear down my spine. We've got many challenges in front of us with these plays, and I guess my concern is that over-regulation could potentially dismantle any opportunity we have. That's my message for the panel. So basically, our proponent would be, let's collect the data and understand where we need to go. Where do we support a prescriptive approach to regulatory change? We strongly support a prescriptive approach in relation to codification of well integrity management. There are many instances of best practice, industry best practice, now codified now in relation to well integrity. Geoff will talk more about well integrity, but we believe there's definite room for improvement in the current framework in that space. We support some prescription around land access. We actually strongly believe the current framework we've been operating under, all the principles that we've been operating under and the framework that we've been operating under are adequate, but they're not in a legislative state. So we'd support a robust legislative land access position. We'd strongly support the concept of exclusion or no-go zones, national parks, residential areas, urban areas with buffers. Yeah, we have no issue with that at all. Sacred sites, sites of cultural significance, these should be no-go zones, and we strongly support it. Where we'd argue that a prescriptive approach to or an exclusion zone, say around fractured zones, that's where things start to get a little more grey for us. Yeah, we'll be acquiring our 3D. We'll be doing our critical stress modelling. We'll be working up. We'll be letting the data tell us, perhaps. I mean, fractures are fractal, so they occur at many scales. Where do you stop? Where does the exclusion limit occur? We'd argue that requires a much more risk-based, objective approach, that sort of issue. Where should regulation be objective and not prescriptive? Limiting the operating window would be a big deal for us. We think it would have a massive negative impact on us over the long term in a large-scale unconventional development. Geoff will talk more about the efficiencies and the cost implications of limiting the operating window, but for me, it would immediately impact on our intent for local content, local contracts, local jobs. It would have an impact. We'd be expecting people to down tools for 6 months in Katherine if we were employing people in Katherine or Tennant Creek or Daly Waters, and we just see that it would represent a real imposition to an efficient and sustainable development outcome. So again, we understand some of the intricacies of it, and Paul will talk to the water issues around that a little more, but we would argue against a prescriptive approach. Dictation of well spacing, a prescriptive approach to well spacing. We understand that the US industry, the unconventional industry, it's transformed the states, it's rapidly evolving, technology is moving into new areas all the time. In the US now, they're drilling 6-kilometre laterals. If we've got a 16-well pad, 6-kilometre laterals, a 500-metre well spacing, and we've got an 1,800 square kilometre play area or viable play area in EP 161 where we're the operator, then that sort of, the capability of achieving that sort of lateral length would actually result in a much, much smaller footprint on the surface. 50 square kilometre spacing between well pads, focused infrastructure and gathering systems. So again, we would urge that we don't take a prescriptive approach to dictating development footprints at this stage, and we let the early information tell us. we need to get the data, basically. On water, we note in clause 7.4.1.1 in the report that all the major companies with exploration permits have committed to not use surface water. Actually, it's not something we've committed to there. And again, we would argue against a prescriptive approach. It's not our intent to use surface water at this juncture. We would, and Geoff will talk to that as well. But certainly we would argue that we need an objective-based position on that, and a risk-based approach. On baseline studies and the whole data gathering exercise, Paul will talk more to it, but we recommend that baseline studies, and we're already involved in setting up some studies that we believe are going to be really important in the long term to monitoring the progress of our industry. We would argue that those studies, which take time, occur in parallel with our exploration and early appraisal processes, because actually the exploration and early appraisal processes are baseline studies themselves. They're baseline studies for information gathering on the rocks and on the fluids and on the geomechanical state of the earth. All that information, we would argue that's a low-risk enterprise, and we would argue an objective approach. We'll discuss other issues such as restoration guarantees and bonds, etc., in our written submission, Madam Chair. But I guess, you know, ultimately my message is we strongly support the requirement for a more robust regulatory framework. We would, where it's possible, we would argue that should be an objective and risk-based framework, and we just, you know, have that lingering fear that an over-prescriptive approach and over-regulation has the potential to seriously impact and perhaps destroy what we think could be a great opportunity for the Northern Territory. That's my piece, and I'll hand over to Geoff.
Thanks, Bill. Morning, Chair and panel. As Bill introduces, I'm Geoff Atherton. I am responsible for well engineering and well construction within Santos. And this morning I'd like to discuss two main areas. Firstly, well integrity, and secondly, feasibility and pros and cons of operating all year round in the NT for well construction. So we consider well integrity at all stages of the well's life cycle, including fracking, drilling, production operations and long-term isolation, post-abandonment. So I'll go through those in sequence. So if we consider the geology in the NT first, particularly shale development, we don't anticipate significant well control or well integrity issues while drilling exploration, appraisal or development wells. We consider the geology to be relatively benign, and considering that currently we don't believe the shales will flow without fracture stimulation, we believe we have a very low well control risk. The interim report questions integrity of structural strength of our conductor casing or conductor casing of the well, and if it's affected by the subsurface caverns that we may intersect. I'll just summarise how we design the wells, and then we can see how it is affected. So basically, we anticipate the wells that we're drilling for shale to be similar well designed to what we run in the Cooper Basin. Now, Cooper Basin wells and the anticipated wells up here, the surface casing, which is an X-casing string below the conductor, are set below the cavernous sections, has sufficient strength to take the whole of the well loads without any structural strength requirements from the conductor casing. So in actual fact, the purpose of the conductor casing, it isn't to provide structural strength, as you may have offshore. It's to basically provide a conduit to allow us to circulate drilling fluids, cement, while drilling the surface hole and setting surface casing. And it also gives us the isolation of the aquifers whilst we drill down deeper to minimise contamination. With respect to well integrity during fracking, later this month, on the 20th of August, we have our 50th anniversary of our first fracking operations in Australia. During the last 50 years, we have had 0 incidents of well failure while fracking, during fracking operations, or well failure caused by fracking later in well life. Hence, we don't consider to be any well integrity increased risk by fracking versus not fracking. I'd also just like to make a few comments about long-term abandonment, which is a discussion point in the interim report, and where we stand on that. Santos management system has a standard for abandonment of wells. This is consistent with both API and NORSOC, which is a Norwegian standard and generally considered to be the highest global standard for well barriers and abandonment. In both the Santos and industry standards, there's a requirement to isolate hydrocarbons from aquifers. And in the shale plays, there's a considerable depth, sometimes thousands of meters between the shale and the aquifer. So it should be, and we believe we have good oil conditions from the well we've drilled so far. So with good oil conditions, good vertical separation, we don't anticipate problems isolating the hydrocarbons from the aquifers for long-term abandonment. Additionally, we, like most of the industry, consider cement to be the only long-term material used for abandonment and require a minimum of 30 vertical meters of cement to isolate different geological boundaries, aquifers, and casing strings. The cement that needs to be verified by tagging to confirm the asset on depth and pressure tested to confirm pressure integrity. So we are satisfied that with modern standards that we use for our permanent abandonments will prevent future leakage or well control issues. And on reviewing our well files, to my knowledge, in our history in the Cooper Basin where we have thousands of wells, we currently have no wells that have been permanently abandoned and are now leaking. So although I'm very confident in our commitment and ability to ensure good well integrity and good long-term isolation of permanently abandoned wells, as Bill mentioned, we are supportive of a code of practice, similar to some of the other states, to ensure that the industry has a minimum standard for critical items like well barriers and well integrity during all phases of the well life, and that we manage that consistently throughout the industry. Secondary I'd like to discuss is running some of the pros and cons of running well construction operations throughout the whole year, in both the wet and the dry season. And the interim report suggests an option to only operate during the dry season. We and many other oil companies have run and continue to manage drilling and production operations in the tropics, particularly in Asia. In our last campaign in South Sumatra, we drilled 14 wells. We put 6 of these on long-term well test. We operated throughout the year and we had no spills and contamination. It just takes different level of planning. And I think with sufficient planning, consideration for local terrain, weather and conditions, I believe we can manage our operations here without incidents. Some of the options we may need to take, we may need to cover tanks to prevent overflowing from rainwater, or seal roads and locations with matting or other products to allow safe movement of vehicle, and control runoff of rainwater to prevent flooding. We also can prepare the sites to allow full containment of fuel, fluids, chemicals, and separation of hazardous and non-hazardous materials. So having said we think we can manage all year-round operations, we should probably just discuss some of the inconveniences and costs associated with restricting operations in the dry. To the dry, yeah. To the dry season. So if we restrict operations in the dry season, it will result in a cyclic work programme and restrict employment for locals, providing labour, support services and any other support that we may need for operations, which I suspect will create local issues. We also consider that water is actually probably significantly easier to manage if we run all year round. If we run all year round operations, similar to what we do in Queensland today in our CSG operations, where the rainfall is actually annually almost exactly the same as the daily waters Beetaloo rainfall, it allows us to recycle fluids. So it allows us to take drilling fluids, reuse them on the next well, the next well, the next well. So we don't have a storage and disposal area, which minimises waste, minimises the amount of fluids we have to remove from the site, and allows us to take what currently may become a massive issue at the end of the dry season of where do we store, where do we dispose of reasonable quantities of fluids. We just reuse them and transport them from site to site. And in actual fact, if we go to bigger pads, on a development case, we won't even be moving them from site to site. They'll just be continually in the tanks for us to be drilling. It also allows us to potentially consider using surface water, as Bill said, because if we've got lots of water around us, it may be an easier and lower risk and lower cost option to take surface water rather than bore water to top up our recycled water. The other consideration of operating all year round is that if we only ran during the dry season, we need to do something with the large amount of kit that we've got. The most likely outcome is that we'll be redeploying the equipment outside of the area. So if we look at the nearest spot that we would move large drilling rigs, frac spreads and other operations, it's most likely taking a 3,000 kilometre journey back to the Cooper Basin and back up twice a year. So we estimate the additional cost of operating a dry season only drilling operation to be about $15 million a year per operator during the exploration phase, and up to $50 million a year during the development phase, as we move equipment in and out, large pieces of equipment in and out, and have to manage the surface issues. This seems like an unnecessary burden to projects, and more importantly to local communities and workforces and services that are supporting us.
Not to mention safety and road safety.
So to close, with consistent practices, I personally see negligible short-term and long-term well integrity risks and feel there are more benefits from managing operations year-round than restricting activities in the dry season. And I'd like to hand over to Paul to discuss collecting data, health assessments and groundwater.
Good morning, Madam Chair and members of the scientific panel. As Bill mentioned, my name is Paul Wybrew, and I have the privilege of hosting several of you in Roma last week. For those that I didn't meet, I lead a team of technical environmental professionals within Santos. Much of my team's work is on Santos's Queensland assets, wherever data acquisition or monitoring is required. Based on my review of the interim report and the information request that we've now received, I understand that some of your remaining work now relates to more location-specific assessments and hence the need for more location-specific data. The panel throughout the report has noted the challenge around this and that a limited Australian data set exists with shale gas developments, and that's simply because there aren't any. And therefore, I think US analogues have had to be used in your report. So therefore today, there are three overarching themes that I would like to discuss. Firstly is the acquisition of the right data at the right time, and then given the early phase that we're in, which is planning for exploration, how every opportunity is ahead of us to acquire that right data at the right time. The second thing I'd like to discuss are human health and ecological risk assessments, and how that's actually interrelated with the first theme that I will talk about. And lastly, I would like to talk about groundwater recharge and uncertainty, and then also how modelling and monitoring can manage the risk of those localised adverse impacts. So, firstly, data, and I strongly believe that exploration is the right time for data acquisition. And actually, if you think about what exploration is, it is only done to acquire data. Obviously, the data is used for a range of geological and engineering purposes. However, importantly, data is also acquired during exploration for a diverse range of environmental purposes. Baseline data is acquired to identify environmental values on the ground and then used to inform environmental, social and economic impact assessments. These are then used during regulatory approvals processes and then during development planning, should it proceed on to that phase. Characterisation data is also collected to inform human health and ecological risk assessments, and I'll discuss these more in a moment. Monitoring data is also collected to demonstrate performance and compliance with the regulatory or statutory obligations. Therefore, much of the data to complete local specific assessments will be collected during exploration activities. And this is simply because some of the data can't be collected without drilling and testing wells, and that particularly relates to flowback and solids management, which I'll talk about in a moment. So because of this, we provided links or references to baseline studies, impacts assessments that we have performed for other areas in other jurisdictions. And the purpose of this was to show how we go about identifying values on the ground, what technology and methods are used to collect data, and how we assess risk. These documents also demonstrated our avoidance, minimisation and management controls, and provided details around ongoing monitoring programs when the projects proceed. I just want to link this back and note to Bill's comment on the precautionary principle and how critical it is that the regulatory framework enables the acquisition of this data and allows these scientific assessments to occur over time rather than simply ruling out something now in the absence of having such data. So moving on to the human health and environmental risk assessment. So I note 4 areas where the panel is seeking localised or more specific information and data. These relate to flowback, spills, solids management, and then the health assessment. And the reason why I've grouped these 4 together for this discussion is that I believe they're all interrelated, and the challenges that you'll have in actually assessing risk. So similar to the data acquisition that I just mentioned, some of this data we don't have now, and much of the data will become available during exploration once we can actually test a well. So therefore, similarly, we provided a methodology for performing human health and ecological risk assessments as part of our submission to your inquiry. The methodology described the characterisation for both the flowback and the drilling cuttings, and then it showed how the data is incorporated and presented, and I'll emphasise the word presented, in the risk assessment reports. The methodology also describes a range of best practice tools and models that are used to support these risk assessments, and much of those are coming from US EPA guidance. And then these are used to assess a range of things such as the risks from overland flow or from hypothetical spill scenarios and the potential for migration through the Baddeley zone. I'd also like to mention that whilst we provided these references to you in our submission, that all of these assessments are publicly available on our website, and they have been since 2011, and they remain to be there now, and they're updated as more data. So it's actually an iterative process of update. Moving on to the last topic, which was groundwater and recharge. And particularly in the context of the uncertainty range that was presented in the interim report. The interim report stated that the published groundwater recharge rates for the Baddeley Basin range between 100 gigalitres a year and 330 gigalitres per year. The interim report also quantified the potential take of groundwater from these aquifers by a potential shale gas industry at an average of around 2.5 gigalitres per year. So, given that the take of water is in the range of 2.5% to less than 1% of these published ranges, it is important to consider whether that range of uncertainty is actually important or whether it's a purely academic question. That said, I also agree with the panel's interim recommendation that localised modelling and impact assessment supported by monitoring can manage such risks. And I also wanted to note that following your visit last week to Queensland, and that unlike Queensland, where a significant number of landholders source water from the actual target coal seams, gas-producing coal seams, no landholders take water from the target shale gas reservoir in the Baddeley Basin, and in fact, we believe it's likely to be at high risk that there is no water, but that's yet to be proven through data acquisition. And that any such inference or similar or related impacts must be considered in this context. And I also understand that you met with the OGA last week in Queensland. I'm sure they've discussed how groundwater impact assessment and management is undertaken in Queensland. So to close, given that we are at this very early stage of planning for exploration, that every opportunity is ahead of us to collect the right data at the right time and for it to be used to inform risk assessment and the management controls that are needed to manage and mitigate such risks. And I clearly want to emphasise that point, is that we do need to manage risk but not perceived risks. For this reason, it's critical that the regulatory framework enables the acquisition of data, recognising that some of this data will be collected over time. I'll now hand over to Tom to discuss access.
Thanks, Paul. Madam Chair, panel, with regard to the panel's comments and preliminary view on accessing pastoral leases, we make the following comments. We recognise the strong relationship between pastoralists and the land they lease. In some cases, that connection stretches back generations. As we advised at the previous hearing and in our written submission, we have a long track record of respectful and constructive engagement with landholders. We don't think a right of veto is appropriate for the reasons enunciated at page 124 and 125 of your interim report. We note there is no statutory requirement to enter into an agreement, though the department's guidelines are clear about the need for an agreement before exploration activities can begin. But as Bill flagged, Santos would support the panel's preliminary view of giving these guidelines legislative force. Santos would also support the panel's view that there needs to be a standard form of land access agreement. And we would also support the creation of an independent body like Gasfields Commission Queensland to facilitate communication between the stakeholders. That body, let's call it the Shale Gas Commission, should include representatives from the land councils, the town councils, Charles Darwin University, the Cattlemen's Association, and of course industry. With regard to the panel's view that gas companies should pay all legal fees associated with the negotiation of land access and compensation agreements, we note the Gasfield Commission Queensland's very recent report on the lessons learned from the development of the CSG industry. In that report, the Commission, drawing on the Queensland experience of all relevant stakeholders, says it should not be common practice to have lawyers representing a landholder's operational and commercial interests. It says landholders should be sufficiently informed through standardised agreements to engage lawyers only at the end of the negotiation, just prior to signing. The Commission also says quite clearly that legal fees in this context should be capped, as happens in other jurisdictions like New South Wales. Santos pays a landholder's reasonable legal fees to an agreed value, but does not support nor consider it conducive to constructive relations an obligation to pay all legal fees. Sadly, there are law firms which take advantage of this situation. Capping legal fees will minimise the risk of what the Commission described as the bullying of landholders by lawyers. I'd now like to pass to Shay for some comments around Aboriginal land issues.
Thank you, Tom, and good morning, panel. Firstly, I'd like to pay my respects to the Larrakia traditional owners, elders and law people. So my name is Cockatoo-Collins and I've been worked with Santos for many years. So today I'd like to address a small number of items from the specific chapters in the interim report. The contributions I share today will be followed up in our written response to the interim report. So if you'll indulge me, I'll refer to you please to page 6, the second last dot point with the heading Aboriginal people and their culture. And I quote, "It is the panel's assessment that Aboriginal people have not been given enough information about the potential risks and benefits of hydraulic fracturing." So we offer the following response to that observation. We agree that the majority of Northern Territory's Aboriginal people have not been afforded enough information, especially factual information. This is likely the case because the number of Aboriginal people that are hosting exploration activities on their land is very small. I would offer to suggest that directly impacted traditional owners that are hosting activities are very well informed. Not only are they well informed of the activities, they are active participants in the planning, approving and delivering of work schedule activities, which ensures the protection and integrity of culture. Page 89. We note that ARPA, the regulator of the Sacred Sites Act, in their submission to the panel, indicated that they have limited capacity to assess, analyse and interpret subsurface impacts. We acknowledge and respect the important role ARPA play. However, offer to share the process we follow in terms of cultural heritage clearances and approvals as an example of differing roles from the Northern Land Councils from ARPA. It is traditional owners who have the authority to seek protection and know that the disclosure of sacred information also remains protected. For this reason, we engage with the traditional owners statutory representative body to carry out the cultural heritage clearance surveys with traditional owners on the ground. We then receive a report from the Northern Land Council detailing exclusion areas, operating conditions, and any other requirements of the traditional owners. We then submit this report with our application to ARPA. Our view is that Aboriginal people's information is private and should be protected. That is, remain within the confines of its statutory representative body, in this case the Northern Land Council, and that the governing agency or regulator's role, that is ARPA's role, is to ensure the compliance to the Sacred Sites Act, which delivers protection to sacred sites and significant sites. Page 90. It is imperative that accurate information is provided as soon as practical to Aboriginal groups likely to be affected by fracking, and the peak bodies with responsibilities for carrying out this work give the highest priority to ensuring this occurs well in advance of requirements for decision making. We agree, and this is the process. Page 91. The panel also notes that there is no basis under existing site protection legislation in the Northern Territory for Aboriginal custodians to prevent work on an underground rock formation, even if this is based on Aboriginal traditional beliefs, as long as the works do not affect any feature of the surface landscape. The definition of a sacred site, while broad, appears to preclude this. The panel has sought the views of the Land Councils and ARPA on this issue. We offer the following information in relation to this observation. I provided a brief summary earlier of the pre-work involved in selecting potential well site locations and the necessary cultural heritage clearance works for those potential sites. It is during these clearance work surveys on the ground which allows traditional owners to identify and map sacred areas and or significant areas of significance, together with their expert advisors, which include anthropologists and or archaeologists. This allows for effective mapping of immediately identifiable areas that are likely to be considered exclusion zones, whether they are at surface or whether they are at subsurface. The operator, for example Santos, then incorporates this into its project planning and management plans to ensure site avoidance and protection. If an area is identified and defined as an exclusion zone, we do not operate in that area. The Northern Land Council Cultural Heritage Report would capture and report these exclusion zones, and we would then include that in our application for ARPA certification. This allows formal registering of sites and allows the agency to be able to regulate for compliance against conditions of the certification. Pardon me. Page 119, we would like to respond to the following statement that there can be no doubt that the absence of right to veto at the production phase places traditional owners in a difficult position at the exploration phase, which is the only point at which they can exercise their veto right, because the information that is available with respect to the production at the exploration will be very limited. This may be an accurate description under the Aboriginal Land Rights Act and may be the case for mineral resources. However, I offer the following information which continues to ensure that free, prior and informed consent for petroleum activities, both exploration and production, is legally provided for. Operators have an exploration agreement in place for exploration activities only. I am mindful and respectful of the confidentiality clauses in this agreement. However, I can share clause 11 and its 19 subclauses. Require the negotiation of a production agreement. A summary of the version is this: the operator shall not commence a production operation on the permit area until it has executed a production agreement in respect of such production operation. For the avoidance of doubt, nothing in this deed is or represents the native title party's consent to the grant of a production interest or the commencement of a production operation. So I would respectfully suggest, Madam Chair, that you request the support of the Northern Land Council to assist you in obtaining the consent of the exploration agreement parties, only the relevant clauses, of course, for you to be provided copies of, only the relevant clauses, as I said before, to evidence that the organisations making these statements, as referenced on page 119, is not universally accurate. And I thank you for your time.
And we're happy to field any questions, of course. Madam Chair.
Thank you. Your exhortation that it would be a restriction, over-regulation, I think is the word you used, to preclude activity during the wet, was that limited to just production, or was that also included exploration, fracking, drilling?
We would say through the life cycle of the project, we would harbour a desire to have no limitations on the operating window, regardless of the activity.
That's not the position of Origin, which says that it's, in light of the precautionary principle, that exploration, fracking and drilling, that they would be content for that to be limited to the dry season. Why is your position different from Origin?
Perhaps it's a reflection of Origin's operational experience, perhaps. We feel that will be very restrictive, and we feel that it would have a major deleterious impact both commercially and in terms of efficiency of operation through the life cycle of a project. That's our position.
But I think it depends where you're actually operating. I think that if we had locations we wanted to drill in a flood zone, then we would not operate in there.
And in fact...
So we would, considering the area is so large, we would want to select, exactly like we do in Queensland, select the high point, actually in the Cooper Basin as well, the high points to drill during the wet, and the low points to drill during the dry. So we would selectively manoeuvre our operations to make them as efficient and as inconvenient as possible.
I appreciate that's what you would do, but I just don't understand why, if this is not a problem for Origin, it's a problem for Santos.
Well, we just see it as we have completely different perspective. We think it will have a major impact on the efficiency of any development. And
Is this something that will be covered in your written submissions?
I'm sorry.
Is this something that you'll go into further detail in your written
Yes, it
submissions?
is.
Thank you.
Yes, Madam Chair. I'll add that for the most part, the origin acreage is in a more low-lying aspect. So we do have some advantage just purely by virtue of the geography of our position. You know, in the operations in the Cooper Basin, as Geoff said, whilst the rainfall is low, we have tremendous volumes of water running down major distributaries into the big lake systems in the southern part of the basin, and we are managing that. We manage that, the logistics of that, with I would say the benefit of experience.
You mentioned, Mr. Wybrew, that there were no instances of wells leaking in the Cooper Basin. Over how long a period is that sort of measurement taken?
What's the,
I mean,
sorry?
if we've only got a 50-year, I think you said you're celebrating happy birthday,
Yeah.
by the way, or 50th anniversary. But I guess one of the criticisms that's been made frequently is, and I think Dr. David Close is on camera saying, well, nothing lasts forever in relation to cement and well integrity. I'm just wondering because one of the criticisms that's made is, well, we don't have sufficient data to understand what the likely lifetime is of well integrity.
That is true. I mean, we have wells, the first wells were drilled in the Cooper Basin in the 60s.
Yeah, late 50s.
So the exploration wells that were drilled in the 60s are still sealed. I mean, that's the best we can say. And I would say over time, where well abandonments and well integrity management has improved. So, you know, we've got the last, however many years, that is 60 years of history, 70 years of history to go at, of which we have no issues at all. Now, so I think you've got to look at it and say, it's not even the old wells where maybe the standards were not as great. You've got to balance the risk of the leak in the first place. So we've got normally pressured reservoirs, which we're going to have up here as well. So that would restrain some flow. And also, you know, the science behind the cement is, you know, Halliburton in particular have done lots and lots and lots of laboratory testing, and you only need a matter of, you know, a metre or 2 metres of isolation to give you significant pressure isolation. So if we're putting 30 metres of cement, that is a huge volume of vertical cement. So we have, 70 years of history, of which we have no isolation issues. And as time has gone on, we've increased the quality of abandonments as well.
What sort of testing occurs? How do you monitor the leaking wells? Again, this is a question that comes up frequently with the public.
So it's a really, really good question, and it's really good to take the analogy to the Cooper Basin. So our general principle is we abandon a well that it's going to stay abandoned forever. Now, we are lucky that we've been operating the same field for the past 60 years. So, and we've got lots of wells that are within accessibility. So we have an integrity program. We go around and test every well. We have all our wells ranked. We test them on a frequency of risk, essentially. And although we don't have an active abandonment program, we do visit those sites randomly, I would say, of where the abandoned wells are. And we haven't had any incidents of.
And we monitor pressure at the well. And what
Yeah,
are the
so
methods of monitoring?
on the wells that are producing wells or that are suspended, we have lots of wells that are suspended. We have a continuous monitoring program where every well gets visited within a 6 to 12-month period, depending on the risk of that well. And we monitor pressures, we do annulus top-ups, and we monitor valve isolation as well.
Just in relation to the number of well pads, there's been a great discrepancy between what the department has envisaged this industry might look like. If the government chooses to lift the moratorium versus what I think the estimates that you've given and other industry players have given. Can you give us any further information on that reason for that discrepancy? It is, again, a matter of some concern to us and indeed the public.
Well, sure. So I think the well spacing, to be quite honest with you, if you turn the clock back 10 years and you say, what is the well spacing you could have if you wanted to drill horizontal wells, technology would have said your longest horizontal section you're going to be able to drill is 1,000 metres and your longest step out is 500 metres to the start of the horizontal. If you move to where we are now, operators are drilling long step outs, as Bill mentioned, like 6 kilometre step outs, and as time goes, every day it gets bigger and bigger and bigger. So I would say that what we think is the well pad spacing today will become, we will have less and less pads as time goes on because the drilling technology will move on. So that sounds really vague.
No, I'm just wondering, does that mean that your estimates that you've given us in your submissions are effectively your maximum estimates, and we can assume that the number might be that or less?
I would say that that's the case. And, as Geoff said, the technology is moving fast. It's our intent, it's in our interest to reduce our surface footprint. It's in our interest to focus our gathering infrastructure, etc., in the event of success and development. Last time in front of the inquiry, I talked about approximately 100 well pads being realistic. Our submission has more. In fact, today I've talked about 36 to 50 well pads potentially emerging from the statistics that I quoted around well spacing. It's a moving feast, and we shouldn't be prescriptive, and I think the public should perhaps take some encouragement in the advances that are occurring in the States in terms of surface footprint of these developments.
So does that mean the department's wrong?
I think what the department's done is looked at the area of the Valkyrie Shale and said that if we develop the whole Valkyrie Shale area, and we did it on this spacing, and I'm not sure that the department will have its own perspective on how things are developed. Perhaps we differ a little, but they seem to have generated numbers out of a much more concentrated surface expression and a much broader area. So our sweet spots in our play, in our area, we think it's about 1,800 square kilometres. We've been consistent in that number, and we'd be working towards minimalising our surface footprint.
Okay, one last question from me before I hand it over, which is just in relation to, I'm pleased to hear that you think that standardised contracts are the way to go. How is it envisaged that the compensation would be calculated?
How would you?
What sort of factors would you be looking at in the calculation of compensation?
Paul, you might help me here from the Queensland experience, but drawing on that, I think all aspects are considered in those discussions, Chair.
But it's quite formulaic.
Okay.
And there are established standards,
Right.
and we'd be happy to share them.
That would be of great assistance in due course, because that causes some degree of difficulty.
Yep.
I'll just start with Dr. Beck. Thank you.
Just some follow-up from the questions from the Chair. In terms of going from 100 wells down to 36 wells, does that mean you're still expecting the same level of production? I think it was 400 terajoules per day, I think, was in your previous submission. Has that number changed? Or
Dr. Beck, when I say 16, I say 16 well pads.
36, I thought you said.
Yeah,
well
36
pads.
well pads. So if we're drilling 16 wells, but we can do it on one pad.
No, I understand.
Yeah.
But the question was, are you still expecting the same level of production? Which I think in the previous submission mentioned 400 terajoules
Yeah,
per day.
the submission discusses 400 terajoules a day. It's a model. What can a single wellbore produce? What's the benefit of a longer lateral and more fracs? We really don't have a great handle on that at this stage, and that's the next foray of exploration for us. What's the deliverability of these rocks? What can we extract from a frac stage of a certain scale? So we have to investigate that at the moment. We have a model.
Okay, I understand. Thank you.
Yeah.
Just some related follow-up questions, if I may. You mentioned the laterals are potentially 6 kilometres. What's the maximum laterals that Santos have been involved in drilling in Australia, obviously? Well, sorry, you've got overseas operations, but let me say in Australia.
Yeah, we haven't drilled many laterals offshore.
No.
Well, no, about 2,000 metres
Right.
is currently what we've done both in Asia and in the Cooper Basin.
Yes.
Is about our limit at the moment.
So it's a significant extension to go from 2 kilometres to 6 kilometres.
It is, but some of it is because of rig limitations as well.
Yes, I understand.
And pressure.
But because, you know, the further you go out, the more horsepower we need. So that would change over time as opposed to being a drilling limitation.
And Dr. Beck, I use that as an example of where US technology is taking the industry, perhaps, and it may be very specific for certain players. But as Geoff said, the geology is pretty benign and receptive to good hole conditions over long sections.
Yes.
Our initial exploration plans involve a 1,000 metre lateral.
Right.
If we can extend that, there are real efficiencies potentially and real rate benefits.
Right. And I was just...
Sorry,
Yeah, just one last question. In terms of the collection of data, monitoring data for the abandoned wells, is there any, I think you said that there's no leakage, but do you collect data and is that data publicly available or is it retained by Santos?
We don't routinely collect data from our abandoned wells. So our general principle is abandoned wells are abandoned. And if we do a drive-by and we see something, which, to be quite honest with you, doesn't happen, well, the drive-bys do, but the leaks don't happen, then we would address it. So our principle is very much, we do the abandonment correctly. We have a lot of faith in our abandonment standards, capability, the way we verify that our plugs are in place, they're on depth, they're the right size, the right volume, and that convinces we've got isolation. And remember, it's not just one plug, so if you go from the bottom of the reservoir, routinely in the Cooper Basin abandonment will take 4 or 5 cement plugs to isolate various geological boundaries.
Yes.
That's a lot of cement in the wells. So we believe if we do that correctly, and if we don't do it correctly, we redo it there and then. So we will not leave a well half abandoned. We will continue until we're happy that we've got the well, that the plugs are in place, they've been tagged, that they're right consistent with the cement set up, and we've pressure tested the final abandonment plug before we come off the well. So that's our general principle, is that we satisfy ourselves that it's permanently abandoned before we depart the
And that's the opportunity ahead. That's the opportunity that's ahead for the Northern Territory government, should they wish to get the right experts together and actually define that code and what those outcomes need to be.
Because I just note that drive-bys are a fairly coarse way of trying to detect leaks, given you know that methane is you know invisible. So
yeah.
okay.
But the principle is we do it right. Our basic principle is do it right and then don't worry about it later.
Thank you.
Ms. Coram.
Thank you for the presentations. I'm just wondering if we could talk a little more around faults. They frequently come up as an issue of concern to the community as a potential conduit for contaminants getting into aquifers and leaking to the surface. Faults can be conduits or they can be barriers depending on the geological setting. And I was just wondering if you could elaborate, based on your experience in the NT, what the behaviour of faults is that you've witnessed and how you deal with it in your bore construction and your fracking operations.
It's probably me as the geologist on our side. First of all, I think Origin were perhaps even surprised in their lateral experience and the way the Origin are not imaging their section well because of surface volcanics. And this compromises the subsurface imagery, the seismic imagery. What Origin encountered when they drilled their lateral was a whole series of small structural perturbations. And actually, when we interrogate our seismic, our current 2D seismic, we interpret a very similar structural setting. And these appear to be small offsets that are confined to the Valkyrie system and are likely the product of the original generative state, oil and gas generation state from the Valkyrie. So they're faults that have actually fractured the system as the oil and gas matures in situ and then emerges from the reservoir system in part. So they're confined. There are some very major structural features that limit the system. Generally, we'll be not focused on those systems because they're taking the reservoir to a pressure and geomechanical state where we would not be that interested. But until we have 3D imagery of the subsurface and until we've done our critical stress modelling and put all our three-dimensional Earth models in place, there's a lot of uncertainty around the system. I would say generally, in a more overall sense, the reason that the gas is still preserved in the subsurface after 1.4 billion years is because it's a passive system and there's very little interconnection through major fractured systems to shallow aquifers or to the shallow subsurface. I hope that answers the question in a reasonable way. But faults, I mentioned they're fractal. They occur for many different reasons. The critical stress state in the Valkyrie and the original hydrocarbon generation phase is what's caused perturbations in the subsurface. We hope to image that. We will direct our drilling with our imagery. And I think, you know, we have a lot of confidence that we'll be able to very much confine our stimulation and the propagation of faults right through the system to the surface is a very, very low probability and it's a very low risk enterprise.
So just to summarise, you'd be aiming to avoid the faults once you've got the 3D imaging. You'll be drilling to avoid faults? My
point is that we will never be able to avoid the smaller faults. It's an inherent part of the Valkyrie system. We will direct our drilling to optimise the landing in the various fault compartments that we expect to encounter. And we would argue that 3D is a critical component, imagery is a critical component of viable exploitation of the reservoirs. There are some major faults that have been rejuvenated through time. They've been passive at least since the Cretaceous and probably since the Cambrian, so 540 million years ago. So the rejuvenation process is intermittent at best, and typically we would argue that there is very little fluid flow along those faults because they've been passive for a long time.
Professor Priestley.
Yes, thank you for clarifying Santos' position in relation to site-specific health risk assessments for the various projects. I was aware of the health risk assessment that was done across the Surat and Bowen Basin in Queensland, although I was reluctant to cite that in the report because it was the copy I have is marked commercial in confidence. So I was interested to hear you say that those reports are actually on the website. Unfortunately, I haven't been able to access that website the last couple of days for some unknown reason. It may be something to do with the internet connection that's available here, but I will check to see that. Now, the comment that you made about being able to undertake health risk assessments for some of the newer projects that are coming up may depend upon getting reliable data. I would have thought that you'd have quite a bit of useful data that you could do at least a preliminary risk assessment around spills and so on, and around the chemicals that you're planning to use, and also about VOCs and so on from those sites. Is that a reasonable assumption?
We will have that data. We haven't done the work yet because we aren't actually planning or in the early planning for those activities. So we have an indicative fluid system, we have the indicative chemical additives that are required. We've already done the hazard assessment component of those yet. What we haven't done yet then is looked at geogenic chemicals, dissociation products, biodecay products, and so on and so on. And then what we expect to come back in the geogenic components. Yeah. We haven't taken that through. Should the moratorium be lifted and should we actually get on the ground and do that, that is the work that will be done to support those activities. Then, of course, we get the empirical data, feed the whole back through again.
But to answer the question, so if we look at phase one, if we just look at the next couple of years of exploration, the answer to the question is yes. So we know reasonably now what chemicals we're going to use, how similar it is to our other operations, and we base risk assessments and our spill management plans and journey management plans and all that type of stuff around that activity. So we're basically saying next phase of work is couple of exploration wells, however many, half a dozen exploration wells, and fracked, this is the scope, and flow back, and so we basically know everything plus or minus on that, except for the missing bit is when we flow back, what are we going to flow? So the risk, of course, is, so the front end, the drilling, the fracking, the running, the completions, all that type of stuff is not that dissimilar to what we're doing elsewhere. We know exactly how we know reasonably how we're going to do it. We build a risk assessment, build the plans around that, and then we build enough plans around the flow back to basically prevent spills and ensure containment. So, and then we use that information to build the development plan.
Yeah, thank you.
Yes, Professor Hart, then Dr. Anderson.
I note that Santos supports the potential establishment of an independent body into, what did you call it, the Shale Gas Commission. But I think, if I understood you correctly, I think you really equated it to the Queensland Gasfields Commission, which is a land access, very heavily focused on land access. Do you see any advantages in that independent body taking additional responsibilities? Maybe take it on notice.
Can we take that on notice?
Sure. Okay.
Professor Hart, it's a big question, and you know, I've emphasised the concerns we have around overprescription,
sure,
and you know, everyone being involved all the time in all the decisions.
I appreciate that, but
we understand.
We're obviously getting a number of people who are mistrustful of the government and government regulations, and one option is an independent. However you make that independent. I'm just exploring where the panel wishes to explore how limited that should be, or could be, how wide could it be. It could be an authority that looks at the whole strategic rollout of the industry. You know, it could go a long way. So I guess I'd be really appreciative of those. My second comment really comes to the baseline information, and I'd seek a comment on whether you're all going to do the same thing. Pangaea, Santos, Origin, whoever else might be involved in the game. I suppose we see some advantages in a bit more coordination approach, if we're just talking about the Baddeley, between at least the three players there. What's your response to that?
I'll actually answer that, Paul. We've right from the outset, we've connected with the other operators who we feel would have similar objectives to ourselves in not just in gathering data, but in terms of facilitating operational and logistics efficiencies, etc. We have an operators body. We meet regularly. We compare information within the bounds of confidentiality, and we would work closely with the other operators going forward, particularly in relation to baseline studies, and we are working with them.
Okay. One other, excuse me, which relates to the recycling, potential for recycling, flowback fluids and so forth. It's pretty vague in all of the submissions at the moment, commenting perhaps on what's happening overseas, which depends on the shale, play, etc., etc. Have you got any more information you could give us in terms of what you think are the reasonable percentages of flowback? Means a fairly large difference in terms, in terms of the need for groundwater.
I think it depends what the fluid is. So if you break down, if you say the flowback is only frac fluid, and forget about whatever fluid comes out of the reservoir, then our general gut feeling is we could recycle about 50% of that. Roughly is kind of the gut feeling. I mean, we need to see what comes back, because we're going to, the frac fluid we will probably be fracking with is basically essentially a clean water system. So we don't think it'll have the chemicals in it that we have in the Cooper, like guar gum and all that carrier type stuff. So it should be cleaner coming back. It should be easy to break, and we'll just have to see what comes back. But our gut feeling, we want to recycle as much as we can, obviously, because it means that we don't have to withdraw, transport, or dispose. So the more we can recycle, the better. The gut feeling for our planning is about 50%. We think we'll be able to recycle.
One more.
Thank you. My last question is, again, I know you've made comments about management of wastewaters and well integrity and so forth, but a lot of the community is still concerned with what happens if the Cambrian aquifer is contaminated. Can you give us just a little bit of an insight? If there was contamination, I mean, this is a hypothetical, what are your options for remediating that?
To be quite honest with you, we are working on prevention. We don't actually think there is a risk to contaminating the aquifer at all, because we think we can drill through it and get it isolated before we drill ahead and get good isolation between, if we look at, let me talk about a preliminary well design, right? So preliminary well design is we set a casing string across the Cambrian with several hundred metres of isolation below it to allow us really good cement bond to say 200, I'm picking numbers out here, so it might not...
Sorry, can I just interrupt? I know all that. I think we all know that well and truly. It's attempting to relate a community concern, if, you know, and you say those and that's fine, but if it happens, and I know it depends on how much and all the rest of it, but if it has, Are there options
Yeah, so
for
Professor Hart, so
remediating
just going back to
groundwater?
Professor Priestley's comment before, so these risk assessments that we make publicly available, we have to go through the process, have a whole range of tools for vein transport modelling, but also looking at do the chemicals actually persist in the first place? And the answer for a lot of those is no. They've actually got very short half-lives or biodecay. So the first question is, are they hazardous in the first place? How long, and do they persist in the environment? And then what is the potential for them actually to reach a receptor, such as groundwater? And we can quantify those using existing risk assessment tools, and it's part of that process that we said that we do, and we do make that information publicly available. We just haven't done that piece of work.
But that assumes that the risk, you manage the risk in terms of spills and so forth to ensure that it doesn't get contaminated fairly, and the same
It's
as well.
prevention.
What if there is contamination? Are there any mitigation methods?
The mitigation is done at the surface.
Mitigation of a, in inverted commas, contaminated aquifer.
Well, then you'd be looking at remedial methods,
Yeah.
either containment, so manage, contain, or active remediation. And there are all various technologies to either pump and treat, back barriers and so forth.
Professor Hart, you're posing a really, really difficult question, and we acknowledge it's a difficult question. I think the first thing that if we had evidence of some catastrophic leakage into a shallow aquifer, our first, there are many natural mitigants, recharge, dilution, half-life deterioration, etc., and reduction in concentrations. But we would monitor the spills, so we would try and track the progress of a spill, and we would seek to perhaps deplete a small portion of the aquifer if it was a focused spill. If it's not a small portion of the aquifer, then we're probably diluting very rapidly into a situation where the hazard is perhaps mitigated. It's a very difficult question. What do you envisage when you talk about a contamination of the aquifer?
We do have to move on, so perhaps this can be dealt with in a written form. Dr. Anderson. Oh, sorry, I should just say we will go through till 10 o'clock today. I appreciate that means that we're running behind time, but if we need to continue on through the morning tea, we will do so that nobody following on will be shortchanged their time. Yes, Dr. Anderson.
Yeah, two questions. The first one goes back to the issue of possibility of setting prescribed distances between well pads.
Yep.
And you talked about how the changing technology means that further and further extensions of the horizontal drills means that well pads are likely to be expanding. But the issue is setting minimum distances, and it's in the context of avoiding possibility of having well pads so closely together that it
polluting
really
the landscape.
transform the landscape.
Yeah.
And which I don't think anyone wants.
Yeah.
And obviously, it's with that technology, technologically it doesn't need to happen, but there's still an issue that the public is concerned about. So I guess my question is, what would you see as a reasonable minimum distance between well pads that takes into account both the amenity issue, landscape transformation issue, but also the technology realities? What are your thoughts there?
I'm sure we've got plenty of thoughts, but we probably should talk to the engineers working on the development plan and the modelling. So if we can take it on notice, and I assure you we'll include it in our written submission.
And my second question is about well integrity, and the panel's heard views of sort of this effect that, yes, even if we can guarantee integrity over even 50 years, 100 years, let's accept that we can guarantee that. Abandoned wells are there forever. What's going to happen in 500 years, 1,000 years? And so let's take the very worst case scenario of 1,000 years' time, we have a complete loss of integrity of the cement plug. In that worst case scenario, what would the consequences be for aquifers that have been drilled through? What would actually happen?
So I think you've got to look at the individual well and how many barriers you've already put in place between the aquifer and the reservoir. So it's not just going to be one cement plug. You will have multiple casing strings. You'll have multiple cement plugs. So the risk of that happening is really, really low. The other thing is you've got to look at the pressure regime of the basin and say, how do you physically get gas that's probably depleted at a lower pressure from 4,000 or say 2,500 to 4,000 metres up to 200 metres when this is higher pressure than this. So the chances of 500 years of a field that's been depleted for its life of actually getting hydrocarbons to flow from deep to shallow is incredibly low. Even if you had no barriers in place whatsoever.
Actually, another point I'd like to make is that hydrocarbons are in specific points in the subsurface, actually, potentially, even moving through these aquifers today, naturally. Yeah, and it's not a destructive force, if you know what I mean. In fact, when at some point between 400 and 500 million years ago, we estimate that something in the region of 55 billion barrels from our area alone, 55 billion barrels of oil has been mobilised to the surface. Yeah, and we're still here. Hydrocarbons are moving through these systems all the time. And so our impact relative to the natural impact, I would say, is probably comparable in some ways. You know, there's hydrocarbons moving through the system all the time, and it is not destructive. It's a component of the system.
Dr. Jones.
Just following up on that particular one, I think the concept that many people have is these systems are still under pressure after decommissioning, and that if the cork pops out, they'll come gushing up the wellbore. And this is a concept which I think everyone needs to work on articulating much more clearly. That this is tight gas. It's not a conventional pressurised reservoir where there could be significant residual pressure. So that's an important concept which I think we as a panel need to address in our report, and you as industry perhaps need to address more clearly as well. But just following up on Professor Hart's question about this issue of flowback water, one thing that concerns me is when you say we'll use 50% of the flowback fluid, 50% is a relative measure, it's not an absolute measure. For example, in the Marcellus, where they say up to 95% of the flowback water is now recycled, well, there's bugger all flowback water that actually comes up. So when you say they recycle 95% of their water, that's really meaningless in terms of the total water demand. So when you say 50%, do you mean 50% absolute of what goes in, or 50% of what comes back?
It depends what the product is. So it basically depends on, we know we can reuse the frac water because it's basically what we've already used. Now, on the assumption that the produced water is similar, or that isn't massive volumes of some product that we're not expecting, then I would anticipate we could use the bulk of that as well. We just blend it with our, I mean, that's what we do today in our current fracking operations. We flow back the frac fluid, whatever comes with it gets reused, irrespective of whether it's come out of the reservoir or whether it's come out of the out of other water sources. Without knowing what the water volume is going to be and the water quality of production, it's kind of difficult to predict. Well, number the 50%, 50% could be 95, or could be, and we could have 100% more water coming back, or almost nothing. So, and I think until we actually frack and test a well, it's pretty difficult to predict.
So
It's gonna be
those
able to
figures that
reuse.
are based on your indicative water balances in your submissions are still very rubbery.
Very uncertain.
Yeah, well, just a second quick question about offsets and no-go zones. The two are related. So, say for example, in Queensland, there's a 2 kilometre offset from an urban area which is defined, I think, as about 200 people or something like that.
Yeah.
That's one type of offset. Another type of offset would be from a sacred site, for example, or from a productive water bore. What are your feelings about these zones? Are they just arbitrary figures, or would you have some more quantitative assessment of what that could or should be?
Paul, would you like to have a go at that? I mean, they are arbitrary, but they feel like a comfortable, 2 kilometres feels like a comfortable buffer.
And the Queensland government put a lot of work and a lot of consultation into those buffers, and I understand you have been talking to the Queensland government. Perhaps they can provide more information around how they derive those. And I think New South Wales has similar numbers, if not the same numbers, and I understand they went through a consultation process as well.
It'd be good to hear in your written submission a bit more on that aspect.
We'll take it on note, yeah.
Thank you. Yes, Dr. Ritchie.
Thank you. Just a few quick clarifications. Most of your work is going to be on pastoral land, is that right?
Yes,
So
largely on one pastoral lease.
Yeah, on one pastoral lease. So when you talk about traditional owners, just the term we use for native title holders. And that you would be negotiating with them to end up with an Indigenous land use agreement which would encapsulate an agreement for all of your operations, and that would then include the cultural heritage protection. Is that, as I understand it, what you were saying?
Yes.
Okay. Now, you were saying that you would then basically take that and to the Aboriginal Areas Protection Authority, and that they would issue a certificate under the provisions of their Act that allow them to issue a certificate on the basis of an agreement, such as an ILUA, with a proponent. Would that be more or less the process, rather than duplicating two processes? I got that from what Shay was saying. Is that more broadly the situation?
Okay, so I mean, you'll find that there are processes that are duplicated with both ARPA and the land councils. However, I mean, that's onerous, it's time-consuming, but we are assured that all of the, we're assured of sacred sites and Aboriginal people, traditional owners in that region of activity are consulted with, and their cultural needs are met.
Oh, no, look, I'm absolutely...
No, that's fine. But there is a process, but I think that if I'm reading your question correctly, I think that applies under any tenure. So you go through a process, but the way it works for Santos, preference is to go again through the statutory body that protects the traditional owners, and then I mean they go out themselves with it without us. They have a process, an established process already in place to cover off all of their traditional cultural requirements, and we are left out of that process, and then, as I said before, it's returned, and then we're able to apply for sacred site certification post that evidence.
Okay, now that might explain it. I've had a look at some of the material that ARPA gave us with their submission. I think the certificates that were applied for, and I'm pretty sure it was included your stuff, was in an exploration phase. Now, nowhere in the actual proposed work or use bit of that application did it actually talk about the fracking process at all. So it was all basically drill pads on the surface and verticals. I'm very interested in your comment that as a matter of your own internal method of operation, that you would be quite happy for exclusions to the subsurface as well as the surface. And I guess my follow-up is, would you mind, in that case, that being regulated?
That's our position.
Okay, so a change in the Sacred Sites Act to allow that to be become part of the way that Act operates. Would that be, I mean, I'm not saying you have to say yes or no.
Yeah,
you consider it.
It's a case-by-case situation, as Shay said. I mean, there are many sites of cultural significance, our understanding, at least from my limited understanding, where the subsurface is an irrelevance, but there may be a site or a trajectory that has subsurface significance. Are we crossing a particular icon that has...
Songline.
Exactly. A serpent or...
And I think if that was identified by the TEOs in that search process, then that could be accommodated under the existing regime.
I suppose I could just be specific. I mean, we've heard evidence, the panel's heard evidence about the importance of, groundwater, which is pretty obvious, and the need to maintain natural flows and springs, that sort of thing. So given that your operations are unlikely, by your own operating approach to affect those, then I could see you'd have no problem with that, having a restriction based on keeping a spring operating.
Yeah, I think the really important thing is the conversation, and the interaction that we have, and the transparent nature of you say we haven't indicated that we're fracking anywhere. We actually have every bit of our program is discussed openly with the NLC, if it's the NLC. I mean, we have a very transparent process there, and in return, we expect to understand their position on sites of significance.
Anything other than this was an exploration phase, so I mean, you wouldn't necessarily do it. I mean, I'm just saying that particular bit hadn't been consulted about.
Yeah.
So just to be clear, you would be at least comfortable with the idea of the protection of subsurface features being considered as part of the regulatory environment that we're...
Yeah, I think we'd have to say we would.
Could I comment on...
yes, no, please, go ahead, Mr. Cockatoo-Collins.
Dr. Ritchie, I think it's important to understand that through the whole process, the traditional owners in those regions and activities, what is determined as a sacred site, both surface and subsurface, is determined by them. They know their land very well. They are very conscious of downstream and upstream ramifications for people on the other side of the language border or other language groups. I think when we hear evidence of people, other traditional owners saying, I don't want this to happen because it's downstream, or it's connected to a spring. What that does is it disempowers the traditional owners who know exactly what's happening, who are again part of the activity, active participants in managing, organising, and essentially engineering our work program to be compliant under the Land Rights Act and the Sacred Sites Act. And you'll find that those people, a very small amount of people, are extremely knowledgeable, and not forgetting that Aboriginal people in the Northern Territory have been dealing with resource companies for decades. And so I think that also plays into the the unfortunate basket that we are here to protect traditional owners because they don't know any different. And I'm troubled by that. I'm troubled by the third parties going out and in a perceived paternalistic manner, telling people that these particular things are going to happen. I viewed yesterday, came in and also viewed it on live stream, both just as good. And one of the traditional owners and participants said it's going to poison my children. And these are the types of unfortunate misinformation that is being disseminated through. Now, we can only do what we can do, and we are certainly constrained, and we respect those constraints and restrictions that the Land Council applies to protect traditional owners in their land. And so third parties and even organisations such as Santos and could be any other resource companies must abide by those rules, and we will not willfully trespass. We will remain compliant, and the traditional owners will, in the areas of activities, will always be active participants and will be compliant under both the Sacred Sites Act and the Land Rights Act.
Thank you. I might just take the Chair's prerogative for one last, I guess, more comment than anything else. Mr. Ovenden, you said that you didn't want over-regulation to destroy the great opportunity for the Northern Territory, but given that the social licence to operate for this industry is tenuous at perhaps best, in light of moratoria here in New South Wales, banned in Victoria, moratoria in Tasmania and elsewhere, surely a degree of perhaps robust and if not over-regulation may well be the price you pay for operating in the Northern Territory?
Moratoria, all product, we acknowledge we have an issue with social licence. We're the bogeyman. Are all moratoria the product of our lack of social licence or the product of populist policy? I'll pose that question. Look, we're strongly supportive, and I've said it, of a robust framework. My fear is, in the face of uncertainty, we overprescribe or exclude, and we take a robust regulatory policy to a place that's uninhabitable for the industry. That's my fear. And I just caution us against it. I just wish it to be taken into consideration. We strongly support robust regulatory policy.
But isn't overprescription perhaps better than underprescription, which is, on one view, what we saw occur in Queensland? And overprescription can then be wound back in light of good industry practice and safe operating practice.
Overprescription can also completely take away any vision to a sustainable future, and we're making big investment decisions early in our processes.
Thank you very much for answering our questions today. We appreciate the time. We appreciate the detailed submissions. Thank you very much to Santos, and I'll now invite the next speaker who has been patiently waiting, and we appreciate his patience as well. Thank you.
Thank you very much.